There's much debate over whether biological male prisoners who self-identify as female should have the right to transfer to a female prison facility. Now, there are concerns that female prisoners could be put at risk of sexual assault and that it could also place undue stress and anxiety on the prison population. Joining us to discuss this further from Belleville, Ontario, is constitutional lawyer Chris Fleury with Charter Advocates Canada. Good to have you with us today, Chris.
Thanks for having me.
You bet. Let me ask, when did Corrections Canada first begin to allow trans prisoners to transfer to female prisons?
Well, there's a bit of a history to this, so bear with me.
Sure.
Essentially, as long as prisons have existed in Canada, they've been segregated on the basis of sex. Beginning around the 1990s, Corrections Canada started to transfer individuals who did have sex reassignment surgery into women's prisons. This was something that at the time was very limited, primarily, and I'm speculating here, as a result of the very small number of people in the general population that were identifying as trans back in the 90s. So that was something that was very limited and on a case-by-case basis. And at that time, it's just worth mentioning that the government of Canada was not allowing people who didn't have the operation into women's prisons, and they were in fact defending that in court. This was a case called Kavanaugh, Cynthia Kavanaugh. This is a person who was denied a transfer into a women's prison because this person did not have the surgery, and an appeal was launched, or I should say human rights claim was launched in the Federal Human Rights Tribunal. That claim was ultimately unsuccessful, and one of the reasons it was unsuccessful is that the government of Canada actually marshaled some pretty significant expert evidence in the form of multiple forensic psychiatrists who spoke about the dangers of allowing biological males into women's prisons. And as I say, they were the government of Canada who took an eminently reasonable position in that case. Was ultimately successful, and that was upheld in the federal court as well. So fast forward a little bit to the year 2017, the government of Canada passes legislation which amends the Human Rights Code, federal human rights legislation, to include protections for gender identity and gender expression. So this is Bill C-16. So around the same time, shortly after, the Correctional Services Canada's legislation is amended in essentially the exact same way. And very shortly after that, the Government of Canada starts allowing, or Correctional Services Canada starts allowing male-bodied individuals, biological male individuals with fully intact male genitalia into women's prisons. This happened first. There's sort of an interim, what they call an interim policy bulletin. As the name suggests, it's an interim policy, but that's what it allowed. And now we have what we're taking issue with in the lawsuit, which is CD 100, or Commissioner's Directive 100, which is essentially the same as that interim policy, but spells out in a little bit more detail the procedure. So the answer to your question is approximately 2017 is when things really started to change.
For sure. And now there's a group called Canadian Women's Sex-Based Rights, COSBAR for short, launched a constitutional challenge against allowing trans inmates to transfer to female prisons. But now the federal government, as I understand it, put forward a motion to strike that down. And so tell us what happened there.
Right. So we were recently in court in early March. There were two motions before the court at that time. One was our motion to establish public interest standing for COSBAR, because obviously COSBAR is a nonprofit organization. The corporation itself has never been in prison, nor can it. So it doesn't have direct standing. So it has to establish what's called public interest standing. So that was one motion. The other motion, as you say, was a motion to strike brought by the Federal Attorney General. They essentially said that we had not properly pleaded the claim, that there were not sufficient what are called particulars, meaning the who, what, where, and when, that was not sufficiently pleaded. Some of the background, though, is that the initial claim was filed last year. Some months after that, the Attorney General actually asked us for what these particulars, there's something called a request for particulars, and they gave us that. We complied, and we sent out, it's something like, I might get this a little bit wrong, but something like 17 pages single-spaced of the who, what, where, and when. They're asking who's assaulted and when, who is sexually assaulted and when, who is harassed and when, and who are the perpetrators, and a number of questions related to each incident. We sent forward answers to those questions, with all except but one question I believe we didn't answer. And they had that. The case law says that those particulars are to be looked at on a motion to strike, which the judge did. And the judge found that essentially the claim in combination with those particulars that we provided was sufficient, that it was not an improperly pled claim. So we were ultimately successful. COSBAR was successful on both the public interest motion, public interest standing motion, and the motion to strike.
Okay, so this is going forward then. All right. Now, what are the main concerns that COSBAR has about transferring inmates from a male prison? What are the risks to female prisoners? What are you presenting there?
So the claim itself is a charter claim. It alleges breaches of a number of different sections of the charter. Section 7, which is life, liberty, security of person. Section 12, which is cruel and unusual punishment. And Section 15, which is equal treatment under the law. So essentially the harms that are being done, what we've pled in the claim, it's a vast array of harms ranging from things like harassment to assault to physical assault, sexual assault, interference with things like programming. So if you remember a prison, most prisoners eventually do get out at some point. They serve their sentence and they're released. So rehabilitation is a major focus of Correctional Services Canada. One of these rehabilitative programs, there's a couple that are at issue. One is something called the Mother-Daughter Program, which is meant to not interfere with the relationship of a mother who's a prisoner and a very young child. So there are cases where children as old as 5 are in the prison itself and in at least accessible to male inmates who are put into the prison. There's also there are support groups, as you'd imagine, for things like domestic violence. And there are, we've heard reports of male individuals who were in fact the perpetrators of violence upon women and children being put into those groups who are there to support the victims of violence. And another thing to just sort of bring out here is that although every person that we are representing in this, the female inmates, they're all perpetrators in the sense that they've been convicted of, in many cases, a serious crime. They have criminal records. So they're perpetrators in one sense, but they're also disproportionately victims. And they're usually, and there are statistics on this, I don't have them in front of me, but they're disproportionately the victims of violence, domestic violence, and particularly at the hands of men. So these are the women who are being subject to this sort of treatment. And this is just one example of having these individuals placed into their program. And what we argue is that that completely negates the rehabilitative effect of these sorts of programs.
Well, it's almost like a re-traumatization, right? I mean, they go through that trauma again, right? At least, there's got to be an emotional impact on them for sure. I would think. Yeah, let me ask another. Just thinking here in some regions of Canada, and for example here in Lethbridge in southern Alberta, I noticed that we don't actually have any female-only prisons that I'm aware of. So they share the same facility, but they do have separate living quarters from the male inmates. So are trans prisoners in these settings are they asking to be sent to a female-only facility, or are they okay staying in a facility where they actually share the same building, I guess, anyway?
So there are, and just to clarify, we're not taking issue with, or the lawsuit doesn't take issue with provincial facilities.
Okay.
Because there
just
are,
federal.
Yeah,
okay.
We should distinguish between there are provincial jails,
Gotcha.
and those are for individuals who are either in pretrial detention, they didn't get granted bail and they're waiting for their trial, or they're serving a sentence of less than 2 years. So people in those institutions, and there's many, many, many across Canada in every province and territory, the lawsuit isn't about that. The lawsuit is in federal court taking issue with federal prisons. And there's 6 of them across the country. There's 5 federal women's prisons and then a healing lodge in Saskatchewan, which is also subject to the policy.
No, that's good to know. All right. Now, one of the arguments in favor of allowing trans prisoners to transfer to female prisons is that trans inmates are at a higher risk of sexual assault within male prisons. So is that the case, statistically speaking? Does that tie in with this at all?
I've heard that argument. I don't know the extent to which it's true. I've never seen the statistics, but I've heard the argument. And intuitively, it does make some sense that they would be more likely to be the victim of a sexual assault in a male prison. Ultimately, what we're asking for in this lawsuit is not for the court to tell the government exactly what it has to do. Courts are very loath to do that sort of thing. What we're asking for is a declaration that the current policy is unconstitutional because of the harm that it causes women. So we don't want these male inmates to be placed and transferred into female institutions, but we're not telling the government of Canada exactly what it has to do in the alternative. Whether that we're not saying they have to be placed in the male prison. There could be another prison. There could be a wing of a prison. There's a number of different options, policy options that Correctional Services Canada has, and we're not telling them exactly what they have to do.
What criteria does the Corrections Canada use to decide whether or not to grant the okay to transfer from a male prison to a female prison?
Well, this is it's actually a very interesting question. The way the policy itself is phrased is that a inmate will be placed according to their gender identity, how they identify, unless there are overriding health and safety concerns. So Correctional Services Canada can review the file, and they do review the file, and they look at what the person was convicted of, what's their criminal record, how have they behaved institutionally to date, if we know about that, and they assess the safety risk, and they attempt to figure out whether or not there are overriding health and safety concerns. One thing that's worth noting, though, is that the definition of biological sex within the policy, it doesn't pertain to, for example, chromosomes, how one is identified at birth, or so on. The definition of biological sex is in relation to what the policy calls current genitalia. So essentially, if someone undertakes the surgery, they are, according to the policy, if they're a man who undertakes the surgery, then they are a woman, according to the policy. And it's, I would say, a perverse sort of policy that is not, in fact, even abided by the government of Canada. They generally, from what I'm aware of, don't take this view. And in fact, there was a recent case called, I think, Cooper. I'm not a part of that case, but I had a chance to watch the submissions that were made in the federal court. And it's Amanda Cooper, I believe. Amanda Cooper's lawyers, they actually made this argument. And because they've read the policy is pretty clear. And they said, actually, Amanda Cooper's a female under the policy. You don't get to consider any of these health and safety concerns. You don't get to consider her history of violence against women, the fact that I think there was some incident involving a female correctional officer in that case. And they said, Government of Canada, you don't get to consider that at all. And the court, from what I'm aware, didn't take up that argument. We'll see if it plays out. That was in I believe, a motion for an injunction to get her into a women's prison.
Well, this is a very interesting case. It really is. Any thoughts on where this will go, legally speaking?
We're hopeful that we're going to be successful, ultimately.
Yeah.
It's going to be a long road.
Okay.
We've been at it for about a year, and we just, as I say, finished preliminary motions, and we're successful. The next step in the case is what's called discovery. So that's where we are going to, actually I should back up a little bit. The government of Canada hasn't even filed a defense. So they're going to be filing a defense in the very near future. After that, there's a process called discovery. So the government of Canada has to turn over all of its relevant records. It's quite likely that there's going to be some disagreement about which records are relevant and admissible and which ones are not. So we'll have to make our way through that. We will, at some point, set the matter down for trial, and I anticipate eventually there'll be a contested trial.
It'll be a while, sounds like. Okay, thanks so much for explaining this to us, Chris. Appreciate it.
Okay, no problem. Great to be here.
Chris Fleury, a constitutional lawyer with Charter Advocates Canada.